Yes.
Okay.
And the reason for the no contest plea is potential civil liability, Your Honor.
And so just so we're clear, the success was completion of programming and no violations.
Correct, Your Honor.
Mr. Hussell?
That is accurate, Your Honor.
Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in a place of confinement. Now, along with that, there's what's called a Killebrew agreement. And what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence. And if you're successful with that delay of sentence, the case would be dismissed. Success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you were going to plead guilty and this person sued you, that guilty plea could be used against you. The no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that?
Yes.
And is that how you wish to proceed?
Yes.
Back on March 31st of this year, were you on probation or parole?
No.
Were you on bond? And then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and/or assault and battery?
No contest.
I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and/or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac and is between Haynes Street and River or Wright Street on the what's now known as something along the lines of the Green Trail or the Green Pathway. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned Round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Additionally, I believe the interests of justice are well established here in allowing the defendant to plead a no contest so as to not have her guilty plea used against her should a case of civil liability arise, although I question what the civil liability would be since there's no injuries, but I guess that's not for me to determine. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. Anytime it's no contest, especially for civil liability, I'm cautious to overly allocute for obvious reasons. But what I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay. I, in these situations, always advise my clients if they don't do well, there is the risk of jail later, the loss of the delay, the public adult record. She's a relatively young adult. She wants to be able to pursue various careers and ambitions. At the moment, she's working at Qdoba. She's aware she owes some money on some older files, but she is going to, I believe, do a wage assignment, if I understand that correctly. She also has some friends with her in the courtroom who've been supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I ask the court to uphold the guilty plea. Thank you.
Hans?
Thank you, Your Honor. This is a disturbing incident involving a defendant and a 14-year-old. Clearly shows some lack of judgment, lack of maturity. However, the defendant does not have any prior convictions. I think ultimately this is a fair resolution of the file. I ask the court to place Ms. Jones on a delay of sentence up to 8 weeks.
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that on me, and I am familiar with Ms. Jones on some other things, but not where she was the defendant. So if the court has
well, I'm just trying to remember. I remember seems like climbing on top of the school for the 4th of July. Was there charges on that?
She reached 18. That was resolved with a civil infraction, I believe. I'm just going purely off memory, Your Honor.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what this type of thing is designed for. A delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones, and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that, but I can tell you, and I'm not using any